we'd like to do now, panel, is ask you to, if you can give us some key takeaways for the event so that our attendees could go away with them. And we're going to do this in the order in which you spoke. So I'd like to start with Jane Yoon, then we'll go to Susan Hirschman, and then finally Sherry Sabat. So Jane, some key takeaways, please.
Sure. Thanks, Sal. I think that the key takeaways from my perspective are really for those of us who are or who represent companies, specifically manufacturers, distributors, those of us along sort of the channel of commerce that are interacting or interfacing with federal health care programs to, frankly, as much as possible, be ahead of the litigation, of course. And in that respect, that really means thinking about, from a compliance or sort of defensive perspective, what our internal programs and policies and operations look like with respect to managing complaints internally, and then secondarily with respect to the type of substance that has that sort of has animated the underlying allegations of the resolutions that we discussed today, giving some thought to how long it has been that we have looked back at the types of programs that have been in focus now for the last year or the last few years, how thorough that review has been, and how can entities really get ahead of the type of conduct that formed resolutions like Baxter, like Agerion, and like Novartis. There's no doubt going to be agency focus on that. That's been publicly stated in terms of all of these interactions, the sort of patient assistance ecosystem, as it were. And there no doubt will be cooperation and collaboration consistent with the trends that I noted at the outset of my talk with respect to DOJ and U.S. Attorney's offices interacting with and working side by side with Relators Council to develop any allegations that seem credible.
Thank you very much, Jane Yoon. Susan Hirschman, a minute or two of some key takeaways, please.
Sure. On the statute of limitations, different jurisdictions differ. Research them. If you have a statute issue on public disclosure, meet with Qui Tam counsel early so you can coordinate any publicity or lawsuit on the underlying matter with a False Claims Act suit. And if there's any doubt, submit your complaint and statement of material evidence to the government before filing suit. On anonymity, if you need it, hire experienced Qui Tam counsel and research the local rules and the law in the circuit on DOE plaintiffs before filing. Finally, on Escobar, talk with the government regarding reasons for declination. And if the reason is materiality, probably not a good idea to go forward with your case.
Thank you, Susan. And Sherry Sabat, some key takeaways.
Okay, on first to file, as Relators Counsel, file as quickly as you credibly can to try to be the first to file. And if you don't make it and you find out a long time later, use all these equitable tolling and other arguments that I explained in order to avoid the first to file rule. As to public disclosure, turn over all your information to the government before filing so you can be considered the original source, and emphasize what is original about your information and why it is materially adds to anything that's out in the public. And also, as to public disclosure, make sure you prepare your client very well for their deposition so that they do not say something that could implicate the public disclosure rule. And finally, look out for that Second Circuit case, which involves first to file, curing, equitable tolling, and lots of meaty issues. And also watch the Medicare Advantage situation to see if the government survives on the United Healthcare case.